let me introduce first Dan Rosenfeld, who was the former head of city buildings and real estate for Mayor Richard Riordan. Had the same role with the state of California, preceding the governorship of Pete Wilson for how many years?
Was under Pete Wilson.
It was under Pete Wilson. I'm sorry. That's right, and it has been a longtime advisor to good developers here in Southern California for the last number of decades.
Yeah, 40 years.
For 40 years,
yeah.
Short time. And joined as well by David Waite from the law firm of Cox Castle, who weekly, is on the front lines of defending, I think most of the time, projects from CEQA litigation. And so, and I'm Darrell Steinberg, I should say. I'm the former mayor of the city of Sacramento and former president of the California Senate, the author of Senate Bill 375, which was one of the efforts to reconcile the balance between growth, which we want more of, and environmental sustainability. So if you are involved, which you are all involved, in any civic issue relating to development in California, the controversy over the California Environmental Quality Act is inevitably part of the discussion. Now, many may not know that the California Environmental Quality Act was actually signed into law by that liberal icon, Governor Ronald Reagan, back in the 1970s, a law that was intended, and in many ways is still intended, to provide vital information to people who are concerned about the impacts of development, and to have the responsible agencies then ensure that the environmental impacts are appropriately mitigated. And, not but, over the course of time, the law has become controversial, in part because it has been used many times for good, but sometimes for reasons other than protecting the environment. And so it is the issue now in the California legislature. I know that the broader issue of permit reform, of SB 375 modernization, of vehicle miles traveled, of permit streamlining, all of it is front and center, especially as authors like Ezra Klein and others are writing these books about abundance and how California cannot build anything anymore. So here we are, and we want to discuss it today among our experts and engage you in a conversation as well. And so I have a series of questions that I hope will guide the conversation a little bit. And let me start out with this. Assuming that CEQA is a problem, and it is certainly a controversy, is it a process problem or is it a substantive problem? In other words, are the substantive provisions of CEQA obstacles to building the kind of development, whether it's housing or clean energy projects, that we want to see more of? Or is it the amount of time that it takes to get a project through? Why don't we start with that and take it from here? Danny?
Well, thank you, and really appreciate your being here with the stature you've had with the state. It's an honor to have you in our community.
Well, thank you so much.
I'm Dan Rosenfeld. I am a hardcore environmentalist. I grew up in Oregon. I've been involved in every environmental organization you can think of, and it's sort of the overriding purpose of my life. But I'm also a real estate developer, and I don't consider that incompatible, because I think the improvement of the built environment and the preservation of the unbuilt environment are two sides of the same coin. And I'd like to quickly tell two CEQA experiences, if I could, that I've lived through. I had a project in a town outside Seattle, biggest project in the history of the city. It was approved one night, finally, by the city council after 100 community meetings. And I got on the airplane to fly home, and the next morning the city manager called me and said, "You should have stayed, because after you left, we exempted you from SEPA," which is the State of Washington and EPA, Environmental Protection Act. And I had $1 million in my budget in a year for SEPA compliance. I didn't realize you could do that. So I asked, well, why can't you do that in California? And the answer is you can. In the state of Washington, if you are proposing a project that's mixed income, mixed use, in a downtown area that has a approved community plan with a housing element and a programmatic EIR, they can waive SEPA, just like that at the city council level. And we can come back to that as why that isn't used more often in this community. The other experience I had was about 2 miles south of here when we were developing student housing next to the University of Southern California. And it was the largest private project in the history of South LA. We had general community support and the university was with us. We got our EIR approved and we were challenged by 2 former USC students who wanted to build student housing themselves, who decided that for $75 they could file a CEQA challenge and tie up our project and stop us. We said no, and we continued, and they challenged us over how much parking these students would need. We fought that step by step, and they weren't getting what they wanted, so they hired a plaintiff and they filed a challenge against a project we had in Sun Valley, in Glendale, I think, north of LA, on CEQA grounds. That project was stopped also. They then challenged a project we were building in Oxnard, and then they went up to Seattle and went after 2 of my projects up there, and before we knew it, they had gone through our website, found 11 projects in 7 jurisdictions in 2 states. They had hired plaintiffs, they had filed CEQA challenges against every one of our projects for $75 roughly each, and essentially put us out of business. And you can imagine what that meant to our investors. It certainly didn't help with the cities we were dealing with, because the CEQA challenge is not against the sponsor, us the developer, it's against the community that is looking, the city, if you generally, that will be certifying compliance with CEQA. And these cities were going nuts. They had thousands of dollars of document requests they had to deal with. And every time we entered a competition on a public site, the first question was, are you in any litigation? And the honest answer was, well, yeah, we're getting sued on every project we're doing, and so is the city that selected us. And that was an existential threat to our company, and that, to me, a classic example of what David might call CEQA abuse. We eventually got them.
This is, I'm interrupt just for a second.
Okay, sure, please do.
This is our third panelist, Jacob. Jacob, nice to see you. Hi. Jacob has decades of experience in the real estate and development area. He's got a long bio that's in your packet. We're really glad to have you. We just started the conversation.
Thank you, Mayor.
Go ahead.
So let me wrap up. I think that, to me, the environmental legislation is necessary. It's appropriate. But CEQA, to me, should try to make good projects easier and bad projects impossible. And if you can somehow get to that objective, you're doing the right thing. It is extremely cumbersome. The technical studies are voluminous. It takes a year to a year and a half
to do it.
And then if you get challenged, you can be in there forever.
So, 2 word, real quick answer. I'm going to turn it to David and then to Jacob. Is the problem more process or substance?
I think it's more process.
Got it. Let's turn it over here to David. The broader question, Jacob, was just what I said. Is the problem with CEQA a process or substantive problem? Is it that it takes too long to get through and otherwise good law and good process, or are there fundamental flaws with the underlying statute itself? Go ahead.
So what I would say is, I'll give the punchline and then I'll explain, I think, the reasons why. So I clearly think it is a process issue as well. When you actually look at the statistics and you look at the distinction between the determination to make a CEQA exemption finding, perhaps to do what's called a mitigated negative declaration as a somewhat abbreviated CEQA clearance document, to doing a full environmental impact report, what you find is that you would think intuitively, well, gee, if I'm doing a full environmental impact report and I'm evaluating all of the project impacts, and we're having public hearings, and there's public comment on that draft document, and the document can't be finalized. And as Dan was saying, it may take a year and a half of public meetings and discourse on a document. You would think, intuitively, that must mean that there must be less litigation if there's an EIR versus a mitigated negative declaration or an exemption. Well, the answer is actually the opposite. Turns out there's as much litigation on an EIR as there is on an MND. And even on the determination to make a CEQA exemption from a project, there's a lot of litigation. What we're also finding is that from a substance standpoint, you don't see the legislature trying to reform those things that an EIR should look at. That is to say, what's fair game in terms of project impacts, what's fair game in terms of the mitigation measures that are crafted by a public entity when it's looking at how to mitigate a project impacts. What the legislature is doing is they're saying, we can't reform CEQA by changing the rules of CEQA. The way we reform CEQA is we do bypass. We do exemptions. We determine those projects that are exempt from CEQA from those that are not. That's how we actually do CEQA reform, I dare say, through the back door. And so what we're doing, and what the legislature in its wisdom has done, because we're so focused on housing, we're so focused on creating more housing, that we now have a series of exemptions that allow for projects to move forward without having to comply with the California Environmental
Is
Quality Act.
that good or bad?
That's a good thing, because that's going to create more housing. And it's interesting, you know, the governor's executive order following the wildfires, which exempted, essentially said no more CEQA clearances for rebuilds on a fire. By the way, that was already in the law. First of all, single-family residential is currently exempt, barring unusual circumstances, right? There is something unusual about a particular property that warrants extensive CEQA review. And that might be, this is the Friends of Berkeley Hillside versus City of Berkeley, California Supreme Court decision about 3 years ago, which basically said that if there is a determination that's made that there are no unusual circumstances, that single-family home is categorically exempt from CEQA review. But it's the question of what about unusual circumstances? Somebody might litigate the question on rebuilding in the Palisades or in Altadena, but there's so many homes that need to be rebuilt. There's so much movement of material. There's so much grading work. That's an unusual circumstance. So perhaps that should not be CEQA exempt for single-family rebuilds. So I think the governor was thinking about this when he decided that the rebuilds should be exempt under CEQA, because we have this unusual circumstance exception to the categorical exemption for single-family homes. My point, Darrell, is that it's a process issue, because ultimately, if there is litigation on a project, that litigation is 2 years. And by the way, if the applicant and the city prevail in court, there's no recourse for the petitioner who filed that lawsuit. There is no ability to say you've completely thwarted a project from moving forward. Justice delayed is justice denied. That project is now dead because it lost its financing, the market has changed, et cetera, et cetera. So in my mind, it's a process issue.
We're going to get to the remedy part of the conversation just a little bit, but let me ask Jacob the same thing. From your experience, what is the underlying problem here? Is it the statute itself, or is it the process?
You know, I'll start, I joke about it, that I send my kids to really good colleges because my company has done for all these years CEQA documents. And the reason is what I hear from Dave and from Dan. I mean, I don't think it's a process. I really think that it went from what needs to be a scientific document about environmental issues that are correct issues that need to deal. It became a legal document. It basically became, when I worked on Playa Vista, we had a document. This was not with Dave's office, but we had a document that was the length of this table. How much can you write? How much can you write for one project? But it was the length of this table, and it was the length of this table without the technical support. And the reason it was that long, because we knew that we were going to go, and we ended up going through 20 lawsuits over the 30 years that this was taken. And basically, the people that wrote the document, the people that sat in my office with my scientist, was the lawyers. And for all the right reasons. I'm saying for all the right reasons, because there was no questions there were going to be lawsuits. And the only way you could protect yourself in court, they all went to court, is to make sure that people like me that can only write 1 + 1 = 2, really listen, really make sure that this guy can go to court and protect and make sure that those 20 lawsuits came out in the favor of the developer. So, when you read the report, it's not a scientific report anymore. It's truly,
It's a legal document.
it's a legal document.
So can I pick up on that for a moment? So let's get to the remedy for a moment, and let's work backwards. Because I think we'd have common agreement that if you do not provide any ability for the public to be able to contest a project that was environmentally destructive, that would not be a good thing, right? If you eliminated all the legal remedies. I know when I was in the legislature, I authored the bill to provide the statewide 270 days for projects valued at $1 million or more of economic value to be able to be heard through not just the trial courts, but through the appellate courts. But it applies to a limited number of projects. We also had a big arena in Sacramento, the Golden One Center, that was important as an issue to me. So if we assume that there needs to be some remedy for a bad project, how do we find the center here? And how would you change the underlying process so that people could be heard, bad projects could be stopped, but good projects could go forward without so much time and delay?
Well, I guess, the question there, it's in the eye of the beholder, right? What is a good
Okay.
project and what is a bad project? But I think at the end of the day, everyone would agree that information is helpful. Information about a project in terms of the public discourse is helpful in terms of reviewing what the impacts of a project are going to be and how those impacts can be properly mitigated. That's a good thing for the state of California.
And what if they're not properly mitigated?
Well, but then there's a problem with the process, right? That to me, if the project has not properly mitigated the impacts, okay, then take your risk, right? Take your risk. But if you clearly have mitigated those projects to a level of less than significant, then you have done the work that CEQA requires, right? But if you haven't, you're vulnerable. You're going to be vulnerable. But I think, again, Darrell, the question is, what's the playing field, right? Is it every project that needs to go through that analysis? By the way, I applaud you on the environmental leadership legislation in terms of shortening the timeframes for those projects in the litigation. But I think we need to do still much, much more in the litigation reform
And
front.
what's the next thing you would do? I want to get at that because I want a little specificity. Would it be a CEQA court? Would it be 270 days for every project? Would it be arbitration? What would it be?
I think that the petitioner needs to have skin in the game. And by skin in the game, what I mean by that is the petitioner has to start to pay the costs of preparing the administrative record, right? So, because by the way, that takes a year in some cases to prepare a record on a complicated project, and that petitioner needs to bear that cost. And by the way, that to me would have the effect of a petitioner saying, is this case really worth is the juice worth the squeeze? Because that administrative record could be tens of thousands of dollars in some cases. For small projects, it's a small amount, but it's enough for there to be a check on the system, which is it's not a free bite at the apple.
Okay.
Because right now it's a free bite at the apple.
It's a good rational idea, and I'm going to challenge it in a minute. But let's hear from.
I cannot agree better. I'm waiting for your challenge.
I'm going to challenge you in a moment
But
because
the idea
it's an
that
interesting
everyone
idea.
the idea that everybody can challenge a CEQA with, at no cost and create such a huge cost for the developer and for any, it's just outrageous to me. And I've seen literally lawyers just doing this in order to get their name up in the paper and creating a name for themselves and not necessarily because they really cared
They cared about
about the environment. So I I think that's a very important part.
Danny, go ahead.
One of the gentlemen who filed the 11 complaints against our project said in his deposition, quote, "We're like Al-Qaeda. For a little bit of money, we can do a lot of damage," unquote, on the record.
Darrell, let me make one other comment on this too, because I've seen this time and again in CEQA litigation. In CEQA litigation, the petitioner has to be a legitimate petitioner, somebody who has a stake in the game. That is to say, they're impacted by the project. They could be a resident, they could be an environmental organization such as the Sierra Club or for the Center for Biological Diversity, but it's got to be somebody who actually can show a real live impact. I cannot tell you the number of cases where legal counsel has feigned the existence of a real live heart-beating petitioner, right? And I have had cases where I finally got discovery and I was able to show that there was no person behind the entity that was suing. So that's another area that is ripe for
Jacob,
reform.
then I'm going to get to my challenge.
Okay,
Go ahead.
I'm just going to say, because I'm going to give another example of, for Dan. I was in one of those lawsuits, and literally the lawyer stands up and says they didn't do this, and then our lawyer, and with my help, says take book book number 27, page number 500, it's there. Right. And the guy would say, okay, we'll go to the next one. And literally, we went for like a whole day, and the judge just went along with this. And a whole day of just one after the other, where he said, they didn't do this. And we would just go and say, check page number 27. When you have a document like this, how could you not deal with everything? And there was literally no consequences to such a waste of time of the legal system.
You appropriately raised the frustration that is heard throughout California about how difficult it is to develop. But here's my challenge. Wouldn't it be simpler to just outright exempt a whole class of projects that are deemed by the legislature to be environmentally consistent with our environmental goals? Infill housing, clean energy, infill development, period, and say, for those projects, we are not going to require you to go through the same process. Because the problem I have with your argument is that while you point out rightfully many cases of abuse, by making a plaintiff pay for the full administrative record, what does that mean for somebody, for example, in an environmental justice community, a lower income community where there's a toxic, Love Canal, where there is an environmental hazard, and they are, David and Goliath trying to get some redress for a community that otherwise does not have a voice. You make them pay for the administrative record, they're never going to be able to challenge that project which is not environmentally friendly. Wouldn't it be easier and better and more effective to just draw a line in terms of the projects that shouldn't require the same level of environmental review? Danny?
Well, I'd suggest maybe you could do both, but I tend to lean towards your direction. I think you do have to have some empathy with individuals and groups that have legitimate concerns. The exemption we got in the state of Washington was that it was a mixed income project, and there was a programmatic EIR for the housing element of the downtown plan. They wanted it, and they said go.
Good. I want to follow up on that in a second, but let's hear from the two gentlemen. I want to ask you about the concept of tiering in a moment, but go right ahead.
Yeah, I think your proposal is the right one. I think we do need to have a class of projects that should be CEQA exempt, and that from a matter of public policy, it includes housing, it includes energy, infill housing. It can, but honestly, why wouldn't necessarily it include first-ring suburban communities as well, where there's already a master plan that has been gone. To your point about tiering, there's already been a process that's been evaluated. But I think we also we really have to address the litigation reform, because to me, I understand your access to justice issue. I do understand that, and perhaps there could be some exceptions. But we have to sort of change the paradigm that if it's a free bite with no recourse, project delayed for 3 years through litigation, that project will die. That will die.
Okay, Jacob?
I support. I mean, you know, there gotta be some consequences to somebody doing something that is just now. And by the way, there are definitely nonprofits and like you that they don't have, you know, that need the support and they don't have all the means to do it. But there are lots that do. So lots that do. So maybe there is a way. I don't know. Maybe there is a way to divide the people that don't from the people that do. But a lot of the litigation is by well-financed
Yes.
nonprofits
To stop
stop
and
projects.
competitors.
Or competitors.
I know
Well, the competitor, absolutely.
Or the labor unions who want a project labor agreement, right?
Absolutely.
So, I'm sorry, Darrell, but that's, they're out there. And they're very active.
Outrage.
So
I
now,
know, it's
now
true.
should we also have
all
projects
true.
that should be without, you know, exempt? Absolutely. There is, you know, I'm working on a 40-acre park. We spent already $2 million on programmatic EIRs, not even on the EIR itself.
Well, so this is the point I want to get to. So I'm a big regionalist. I believe in regional government. And, you know, that was SB 375. The real idea was to have the region plan, not to take away the local control, but have the region plan to say we're going to grow, but we need to grow in ways that are sustainable, that reduce the vehicle miles traveled. It's the old jobs housing balance put into law. And then we authored 743, which said when a city or county does a specific plan, that any project that is consistent with that specific plan is exempt from environmental review. And the specific plan, of course, has to go through a full environmental impact report. Why isn't that, and the existing exemptions that the legislature have passed for infill, why isn't that enough? In other words, tell me what's wrong with the landscape of exemptions that the legislature has already passed over the last decade as this issue has risen, and what more you would exempt that isn't currently exempt.
Who wants to start? I don't think the exemptions are used as widely as they should be.
But why
I think
not?
cities are afraid. You know,
Afraid of what?
Being sued. You know.
The standard
A
is,
lawsuit is a
the
lawsuit.
legal standard is fair argument, right? So
Okay.
if the question is whether or not the city makes a determination that the project is exempt under CEQA, somebody comes in and says, those findings were not supported by substantial evidence in the record, there is a fair argument that that project should not have been exempted. Because of, in the case of a single-family home, the unusual circumstances,
So
right?
change the fair argument standard.
So that may be one. You got to give more deference to the public entity who's making the determination. You've got to give them deference.
Okay, Jacob, agreed?
Absolutely. I mean, I would say, you know, if we think otherwise, we are naive.
I understand.
We're just naive.
This panel, I think, needs one more person who is the ardent supporter of the CEQA. That's okay. It's all good. I'm going to play that role, even though I am for the very balance I think you're talking about. Let's take questions from the audience. Yes. Who is this in the back row? Kathleen Brown.
Panel.
Thank
Great
you.
discussion. Thank you. Darrell, in your spirit of regionalism and in light of the great tragedies that this region has faced with the Eaton fires, the Palisades fire, the governor did his exemption of the Palisades and the Eaton area. But if you look at the impact on the city and the county and all of its jurisdictions of property taxes, they are going to be devastating. And that $1 billion deficit, even without that projection, would it be reasonable to argue that as a region that there should be an exemption for CEQA for projects that meet all of the criteria? You have criteria, it's not a blanket exemption, but there are so many projects in the pipeline
Yes.
today
Yeah.
that have been held up by all the things that you're talking about with great frustration, that if there was a regional exemption, again, with criteria, that you would have a chance of quickly making up some of the property tax loss. And you could even make it for a period of time until, rebuilding.
That's really an intriguing idea.
A thought. It's being advocated by
Right.
a large group
Right.
of builders and,
Right.
people in the community. And I don't know that it's gotten traction, but the impact of the loss of property tax is going to be huge.
If you limited it to housing, if you limited it to clean energy, I think you'd have, well, I'm just a moderator here. I think you would have a fighting chance in the legislature, right? If you limited it to projects that were consistent, the criteria, with good stewardship of the environment, I think that would have a fighting chance. Why not? What do you all think?
I think it's a great idea, and for those of you who haven't had an opportunity to read the ULI, USC, UCLA joint report, and I know Kathleen, you were part of that effort. I was part of that effort. It's really actually a commendable piece of work product, and part of the recommendation that we made, obviously, was really looking at the permitting process, and we're advocating strongly for self-certification for a number of projects, not just single-family residential, multifamily, small commercial. So there's some real promise there. The one thing I will say on the tax loss based upon the assessor value, it is enormous, as you point out. That actually, there's a bit of a silver lining there. The silver lining there is that the increment that we're going to get from that deep loss that the assessor is right now going through is going to be, we're going to have the ability to use that for TIF financing for infrastructure. That could be very potent in terms of doing undergrounding of utilities and doing all the things we need to do to build back better relative to improvements. So while it's very unfortunate that those tax dollars are not going to be coming into the city and the county, there's an opportunity during the rebuild process to use that in a very productive way for public financing, to use that to fund the infrastructure that we need to build. And through the new climate resiliency districts that are available through EIFDs, enhanced improvement finance districts, all of those new tools I think come into play with TIF. So that's going to be an interesting opportunity. And this again is all delineated in the report.
The opportunity to bring tax revenues, it wouldn't offset.
Correct.
Is there an author for that bill?
I don't even know that.
Ben Allen has a climate resilient district bill.
Yeah.
Yeah, but that's already in place.
I don't think that there's legislation.
It's worth talking about.
Yeah, we should talk about it.
David?
Darrell, first of all, the conference bears some responsibility for not having an environmentalist on this panel, that's all.
No. Okay.
But I just want to say, as much as I personally sympathize with the people on the panel, there's a real concern in the other room at the end of the conference of Palisades residents that they're about to see vulture capitalism take over their place, whether it be Palisades or Eden. So when you eliminate all the rules without maybe changing the criteria that you're going to add, that gives them some protection about what they're going to get, because the lawyers up here are pretty good, and the engineers are pretty good, and they're going to start to work for the wealthiest investors they can find. And I'm sympathetic to that. But there's some problems that are come from that if there's no restrictions on what they start to build and start to imagine. And it won't be what those Palisades residents are doing in the other room.
Well, boy, go ahead.
I just want to say, I was the president of Friends of Bariana Wetlands. So I consider myself as environmentalist as anybody. I'm just saying that there are environmental issues. Those CEQAs do have environmental, we need to deal with environmental issues. It is that when it becomes an opportunity for taking advantage of it for all kind of other reasons that most of the time has nothing to do with environmental issues. That's where the problem comes in. But there are environmental issues, no question about it. We should deal with them. We should we should make sure that those are taken care of. But, we get to a point where we don't talk about the science of environment anymore. We talk about everything else other than the real science of environmental needs.
Danny?
Yeah, we haven't talked about the pace of certification. Understanding there are necessary and legitimate environmental issues to review, it can take a year and a half, and I'm on 3 years to get a simple addendum to an existing programmatic EIR in South LA where the housing is needed desperately. There's got to be a way to move these things more quickly.
More quickly. Let's get another question here, please.
So I've been in real estate and economic development. I work for HR&A advisors for 20 plus years, and very much am in agreement that CEQA needs reform. There's some major challenges with it. I definitely agree, though, that there are environmental issues that need to be dealt with. And even when we talk about exemptions, we talk about it for housing, clean energy. I actually just worked on the community benefits framework for the Central Valley community, generally where there are utility scale solar and other projects coming in. And there are going to be harms to the communities that are capturing those projects. And so that does need to be dealt with as well. I think one of the challenges is that maybe you need to find some way to separate actual environmental challenges and the harms and addressing those harms, which is what CEQA was intended to do. And then there's another pathway though, this is also being used as an avenue for people to weigh in on, whether a project is acceptable for their community. If it is actually someone with skin in the game and their residents, they do have a right to be able to do that. And we need to find, perhaps in the CEQA reform, there is something that we find other avenues for folks and give them that capability to really participate in the process. There could be entitlements, but often people are not finding out about things until, it's said and done.
So, yeah.
There's a lot.
There's a lot. Can I thicken the plot a little? And we probably go ahead. We've got other questions, but there's a question I have, but I'm going to let somebody else ask. Go.
Yeah, I actually agree with your position on Steinberg about trying to pick some projects, housing, clean energy, and then work on the rest. But I want to be a little provocative to say, why is it when developers challenge environmental rules, it's negotiations, but when the community does, they're obstructionists. And if you go even further, as far as having skin in the game, I would say their health and the environment is the skin in future generations. It's more weeding out attorneys like myself who are really trying to earn a buck.
That's right.
So trying to get community to put money in is a difficult conversation. So how do we change that narrative? I'd love to hear your thoughts around those.
Yeah, I mean, it's hard for anybody to try to sort of pick winners and losers, right? It's like who's legitimate and who's opportunistic. And I will tell you that I think at the end of the day, it comes down to my standing issue. Who has standing in the community to challenge these projects? Do they have a legitimate stake in the game? And everything that you've articulated, clearly there's a legitimate stake in the outcome of the project. But to me right now, the rules of standing in CEQA litigation are not as robust as they need to be, because at the end of the day, the petitioner can hide behind that entity. Who knows who's actually behind it? Maybe it's a project competitor who's funding the case. Maybe it's some organization that really has some other agenda that has nothing to do with the community. So I think the solution there is really, how do you find a way that you can really unpack the standing question about who is bringing the action? And because in my mind, that's how you sort of sort out the question of sort of what's a real live legitimate concern here versus that which is purely opportunistic by a petitioner's counsel. And there's plenty of those that are out there.
We don't have a common definition of what's in the public interest. For example, you talk about community, and this is a whole nother hour. Talk about affordable housing and workforce housing. For some, that is a vital state and community interest. For others, in some communities who don't want more of that, that's not a community interest. So you can modify CEQA all you want, but if we're not aligned on whether or not we need more quality duplexes, triplexes, quadruplexes in single-family neighborhoods, for example, then CEQA is just one issue among many that need to get resolved if we're going to build more of what we say we need and want more of. That's why this is so, and that's what the environmental community will say. Don't give me this business about CEQA. You don't want to build affordable housing in the Palisades or another neighborhood. So but reform is necessary. It just has to be reasonable. We got one or two more. Go, go.
So, coming from the legislature,
Yes.
what do you think the stomach is for CEQA reform?
So I've always believed that fundamental CEQA reform only happens when a governor decides that he or she wants to take it on. Now, you know, we've made modest changes, again, the 270-day litigation period, various infill exceptions, but I think it requires a governor who really wants to take this on. And by the way, I know Governor Brown faced this. The interests in opposition, including the building trades and the environmental community, it's fierce. It's a really, really tough battle. But I think if we stick to principles, the principle being, take the things that are environmentally sustainable that we want more of, infill housing, and broaden the definition of infill. I'm with you. Clean energy, and say we don't have to go through the same process. Check the box instead. That we've got a better chance of making substantive reform than if we try to develop a whole new system. That's me from the legislature, and it's been a decade now. So, got one more. Go ahead.
The importance of open space, wildlife, habitat, those kinds of things is kind of missing from this conversation so far. One of my concerns is that when we have widespread exemption from CEQA, or we say, well, you burn down, rebuild, it really opens things up to people building where things never should have been in the first place. And it's a different kind of environment, in both in terms of monetary and economics and technology, where people can now build much bigger, worse, imposing, whatever, just because they can afford to. There was a time in the Santa Monica Mountains here where the geology really prevented people from building into the mountains. Although there was plenty that was done, you know, some of it good, some of it not so good. Now technology is not really an issue. You can build a mansion anywhere, or a McMansion anywhere. So the concern that I think that undoubtedly CEQA needs reform, and I really appreciate, you know, the insights into what some of those impediments might be. But the reality that to give a blanket, just go, do it right, but just go, is going to have a tremendous impact. And while we're definitely maybe improving opportunities for housing and infill in some places and this and that, when we're talking about the Palisades, it's not really about, or Malibu, it's not really about infill. It's about how big is this mansion going to be.
I understand. That's what I was alluding to a little bit earlier. What is the public interest here? What are we trying to achieve?
So I think, you know, my response would be both the governor's executive order and the mayor's order limit the rebuild to 110% of the footprint of the house, as you probably know. So you have a 10% margin, a 10% buffer. By the way, some would argue that so long as you're consistent with zoning, so long as that your proposed plan is consistent with R1 zoning, you really shouldn't even be limited to that 110%. But right now, if you want to be fast-tracked on rebuild, 110% is the rule. If you're outside of that, you're back into discretionary land, right? You're into some discretionary approval that you may need from the city or the county if you're building beyond that 110% limit. So I think you're going to still be subject to the rules of the road that currently exist for discretionary projects, and that includes compliance with CEQA. Now, you may be able to take advantage of an exemption for single-family rebuilds that are, again, consistent with zoning. If you're really building out, to your point, beyond the envelope, you're looking at variances, you're looking at, you know, height district changes, all manner of discretionary approvals. So I think that there are some guardrails that probably already exist for that concern that you have, but the 110% rule right now is probably the most potent guardrail to those who want to rebuild quickly. They literally have to pretty much build what was there.
Last question, and then we have to stop. Did you have a question? You go ahead.
Yeah, California's part of toxic substances control, so we oversee many of the things that have to happen before development can actually start. So we get pulled into these CEQA conversations all the time. I'm curious, many of the concerns we hear about exemptions, about circumventing CEQA to some extent, come from a place of fear of what guardrails are in place instead of
It was a question raised earlier about, okay, you say no remedy. I don't think anybody here is saying no remedy. How do you fix this in a way that is reasonable?
So I'm really glad you're here, because one of the issues right now that we are debating on the rebuild is the concept of confirmation sampling, right? We have ash debris that has blown and continues to blow. And right now, both FEMA and the Corps have said, we're not doing it. We think we'll clear it if we take 6 inches of soil off the top. We think we're done at that point. I think there's a huge miss there in terms of somebody's got to go in and actually certify that the hazardous waste and the hazardous materials were removed to a degree to protect public safety. And by the way, it's not just my lot, but it's my neighbor's lot. And it's everything in the region. So the question in my mind is, the open question is this a DTSC role they're going to have to come in and say, okay, FEMA's out, the Corps is done, they've done the debris removal, they said we took 6 inches or 8 inches of soil, we've done these all over the country, we know it's clean. But somebody has to go in and check that, right? For everybody's benefit, the community's benefit, the homeowner's benefit. And by the way, lenders and insurers are going to require it. So that to me is a very, very important piece that's being debated right now. Because we can't, until we get that certification, the rebuild really is dependent upon that certification. So I think that right now that is like the #1 issue in terms of how we do confirmation sampling.
I think we've run out of time here. That'll serve as the last question. Thank you so much to the panel and to the audience. I think we could go on for hours here.